Hello everyone, welcome back to our channel. Good morning, good afternoon, good evening. I greet you all according to your time and locations you'll be watching this video. Yes, my dear viewers, I am back again with another update. So guys, I have a video here I would like we all to watch. But before then, if you're meeting my channel for the very first time, you're highly welcome. Please kindly do well to like, share, and subscribe. Leave your thoughts on the comment section. Let us know what you think about this video, and I will see you towards the end.
Aftermath of the election judgment, there are now calls for the reform of the electoral and legal frameworks, and that's to strengthen the country's institutions for easy acceptance of electoral victory and to reduce litigations in the future. Joining us now is a legal practitioner and activist, Maxwell Opara. Maxwell, thank you for joining us on Newsnight.
It's my pleasure to be here. Thank you once again.
Now, having heard the judgment today, and then with the calls that there should be tinkering with our legal frameworks, where do you think we need to buck up?
Well, I still encourage the parties, Labour Party, PDP, and their presidential candidates to approach Supreme Court, because Supreme Court is a policy-making court. Whatever decision Supreme Court pronouncement form parts of our law. Now, having said that, there is every urgent need for us, for the executive or the civil society group to approach National Assembly, the need to amend our electoral law. This issue of you have few days within which to gather your evidence and approach court, and whatever thing that you have filed, you cannot amend. The thing works against the principle of fair hearing. And I participated partially in this election petition, whatever. And I discovered that one of the challenges they have is getting witnesses, getting evidence. Before you gather them, time was running. So that affected that. Then secondly, I also urge my fellow Nigerians to keep calm. Just like you don't start attacking people. Let us look the fundamentals. Just like our own Justice Mary Audley, he just advised people, advised Nigerians, look at, don't put on the roof. And people now, on my own, I'm calling it transfer of aggression, because Nigerians, they are already annoyed. And when you make comments and as if you are trying to praise or
tell to one side,
I'm saying, they don't want to know what you're even saying. They started attacking you. Because if you watch someone like Mary Audley, he has been attacked by APC government in her house there in Maitama. Now, the same APC government, he was telling them that if you are not declared winner, channel your grievances through the legal process. Don't put on the roof. And we are saying that he was praising Olani Beko and the Attorney General, that they have done well in election petition. Of course, I'm a lawyer. Whether you like it or not, Olani Beko is very good when it comes to election petition.
Yeah, he has
done matters for PDP. Right. He has done for APC. Likewise, the Attorney General. So, and he is Olani Beko handed over to her as the chairman body of benchers. You don't expect her to make comments without at least recognizing her former boss in the body of bencher. So that is the area we are looking at it. So in all, we are asking Nigerians, the Labour Party and their candidate PDP, and they still have one other hurdle, that is Supreme Court. And lucky enough, the lawyer to Labour Party said he has a firm decision from his client, that is P2B, and the Labour Party to approach Supreme Court. So let us watch what will happen.
All right, though we're already getting advice that they should just, let it be at this point so that Nigerians can move on. But let's talk about how all of this case, will change the face of Nigeria's electoral jurisprudence.
Of course, you see, a lot of issues came up. This issue of, because when you're talking about subpoena, a subpoena witness is a witness of the court. Not a witness of the plaintiff, neither is the witness of the defendant. It's a witness of the court. So the presumption is that the court brought the subpoena in court. So, but now, putting it side by side with election petition and our own normal court. So that is a different argument altogether. Because once the Court of Appeal, or the division, has already given a judgment on that, saying that a subpoena witness and the statement made by a subpoena should not be front-loaded. But now, some people are now saying that is a different issue. So we have a conflicting judgment.
Help us understand this so that we
now,
don't
what do I mean by
lose you
subpoena?
there. Yeah, because the question is how this case, I mean, as far as Chief Robert Clark is concerned, he says this is the best judgment that he's heard in his lifetime. The Labour Party Council says, look, this will do a lot of damage to electoral jurisprudence in Nigeria. I'm
saying this thing with due respect to Chief Clark.
Right.
He cannot say that this is the best judgment, because that judgment, when you have the compendium of the judgment and start revealing it, you will see they are human beings, for Christ's sake. And don't be surprised that if this matter travels to Supreme Court may fault some of the comments and some of their decisions. So you cannot say that this is the best judgment to his own view. So this is a judgment that was just given. Just like your last guest said, people have not been able to digest, because on my own, most of the times, while they are reading it, you move out, you come back. When you have the judgment in its entirety and read the judgment and reveal it paragraph by paragraph, pages by pages, you'll be able to make your own summary comment on it. Yeah. So coming to tell us that this is the best judgment, if you should ask me, I'm saying with due respect, he's speaking from a biased perspective.
No, don't let's say it's speaking.
No,
hang on, if you hold on, if you hold on,
to my own analysis.
Yeah, I understand, but if you hold on a little, yes. Chief Clark has just told us what he feels about the judgment. Yes. You have the absolute right also to tell us what you feel. In any case, what we need you to make us understand now is how this judgment today will foster the citizens' confidence in the judiciary.
No, if you watch the entire environment, the entire country, it's just like the day this president was declared winner. Everywhere is calm. Nobody's happy. Majority of Nigerians are not happy. That is the naked truth. Because one, people felt that majority of Nigerians are not lawyers. I can understand it from the angle that this is something you're supposed to do. Majority of Nigerians don't know what to call pleadings. Majority of Nigerians are seeing it from the angle that this guy did not meet 25%. This person has been accused of issue of drug. This person, he lost in Lagos, he lost in this place. It was rigged, the election was rigged in Imo State, in Rivers, in Lagos, and in some other places. So they felt that judiciary will be able to say, no, you did not meet the 25%. No, there are discrepancies in your name, in your age, in whatever thing. So now that you have relied on issue of technicality, which I can understand as a lawyer, the person who is selling Ogo in Karimu market may not understand. So they will give it a different interpretation. So we need to talk to them. We need to, using media, using other avenues to talk to them, because Nigerians, they are not happy. That was the reason why when I started, I said, somebody like Justice Mary Odele that have served this country in various capacity, that have given I'm a lawyer, I have read most of our judgment, and people started attacking because he gave advice. Nigerians don't want to hear that such an advice. Right. So that is what we are saying.
Let's talk about the issue of specificity that the tribunal stressed on, whether in the case of the Labour Party, Peter Obi, and the PDP, that they were not able to say specifically. This was how, say for example, the issue of rigging at some polling stations or violence or whatever. How did it affect, you as a party in so polling units? What number of votes did it deny you of? And all of those. Specificity, how important really is it in helping the petitioners with their case?
I think it's a guy with issue in one of his judgments said that the court is a court of law, but the day never come when it will cease to be a court of justice. What is justice? The parties apply to INEC, telling INEC, allow us to have access to the documents and the reports which you used to conduct an election. They refused. They reported to the tribunal, to the panel, and nothing was done about it. So even the one they gave them, most of them were blank. So now, these particular issues, most of the times, court, when you are reading the likes of Oputa, Nemeka JSC, and I follow them, they will raise issues. Issues like you have the power to make rules on how to conduct an election. And you may also make rules that the result will be transmitted from polling booth electronically. Now, the question there is that they will raise the issue. What to stop the umpire from using that particular transmitting the result? Why should you transmit that of House of Rep, Senate, and fail to transmit that of presidential? They will now, you will now see, based on this, we come to irresistible position that they will now give their judgment. But this period, with due respect, everybody has his own style of giving judgment. So all those issues are the issues which the lawyers to the petitioners felt that the panel did not address, and which is going to form their grounds of going on appeal.
So in other words, what the tribunal was trying to say was that, look, he who alleges must prove.
How do you prove?
And as far as Labour Party and PDP are concerned,
probably